Today's interview is with Paul Seils. Paul is now a visiting professor at St Andrews, but his main job is he leads the Conflict, Justice and Reconciliation Programme at the European Institute of Peace. He was formerly Vice President of the International Centre for Transitional Justice, and before that he was Head of Situational Analysis in the Office of the Prosecutor at the International Criminal Court. We will follow the normal format. I will ask Paul the standard now 7 questions, and that will take half an hour, 25 minutes or so, and then we will open it up for questions from the floor. And after that there will be wine. But don't make it quick because there's wine coming at the end of it. Okay. Paul, start off telling us a little bit more about yourself apart from what I've said in the introduction.
Thanks very much, John. Well, that's I don't know if it's the highlights or the lowlights, but I've certainly done those things that you said. I started off as a criminal lawyer in Glasgow in private practice, and then went into international law through a master's at UCL, and then stayed in that area for the following 20 odd years that it's been. First of all in refugee law here, and then I was in Guatemala for about 5 years in the immediate post-conflict context there, dealing with investigating human rights abuses and working with people there. And one thing led to another, and went into the ICTJ and then the ICC and then the UN in Geneva for a short time. And that's basically been that. It's all been in and around conflict and post-conflict and the sunny side of mass atrocities. That not the sunny side of life, let's say, but it's been all in that area, one way or another.
So you're on the borderline of political settlement and legal matters. What proportion of your working time is spent engaging with matters you call matters of law?
That depends on how you define the law, doesn't it? Do we have time for that, do we?
Yeah, no, that's what this project's about. So,
well, essentially what I do now, and everything that one way or another that I have done, but it's all about rights in one way or another. So, in effect, if I take the specific thing that I spend the vast majority of my time on just now, which is in connection with the Syrian situation, just as an example, the argument there that we're putting forward is that for those negotiations, such as they are, they're not very substantive at all, of course, at the moment, but any kind of idea of progress in the Syrian context would demand, in my view, a serious treatment of the refugee and IDP situation.
Sorry, what's IDP?
So internally displaced people, persons. So over 50% of the pre-war population of Syria is in one of those two categories. If it was only 5 or 10%, you could say it's not the priority issue in a negotiation. If it's 50% of the country, my view is the country's not a sustainable entity without some kind of serious treatment of that at the right time. So that comes down to an issue about the rights of refugees and the rights of return. So although you're not dealing with a court case and an argument in preparing a court case or anything like that, everything that you're doing is arguing about trying to establish conditions that give a meaning to the right of return and the conditions that are necessary for that to happen. And even although those are, in a sense, relatively abstract, or at least pretty far from the realisation of those things happening, that's what the day is spent doing, one way or another. So I would say, insofar as dealing with rights and preparing the ground for the vindication of rights is about the law, then the vast majority of the time is spent doing that if I'm not trying to raise money for things, you know.
Right. So presumably, most of your working is with wanting the background of the substantive law of the subject, and you'll be less involved with procedural matters. But where do you get your knowledge of substantive law, of the law that you are working with and through?
It depends which of those jobs that we talked about we're talking about now. At the moment, and in general terms, if you're working in international human rights law, then the vast majority of what you're dealing with in terms of the substantive law is coming through treaties. So be it the the Covenant on Civil and Political Rights, or Economic and Social and Cultural Rights, or Convention Against Torture. Any of these kinds of well-known treaties would be the kind of backbone of most of the issues there. Procedurally, to the extent that you would call it procedurally, you've got various committees and things that are created around those. So, for example, when I worked in Guatemala, there would be I appeared in front of the Inter-American Commission on Human Rights over 4 or 5 years there. So these commissions or committees are set up as adjuncts to the American Convention on Human Rights that is related to. Where you get the knowledge, so largely the treaties and the treaty base, but in international law you're also dealing with this, what some people call the distinction between hard law and soft law. So hard law would be your treaties and the obvious things that are in those issues. Soft law is a harder thing to describe, especially to people that haven't been taught it in any detail, but essentially you're talking about principles that are established through different kinds of routes, or, so for example, a commission of not a commission of inquiry, but commissions of some sort or another. For example, going back to the refugee issue, there's a thing called the Pinheiro Principles. So Paulo Pinheiro, the Brazilian jurist, came up with these principles about what are the minimum conditions for return for refugees as an example of what could be called soft law. Various other kinds of ideas about almost any area you would care to mention. There are elements of soft law, i.e. not things that states have ratified formally, or i.e. obliged themselves to conform to, but basic principles or principles that are in and around that inform those obligations, and those, depending on what area you're working on, will be relevant for the work you're doing. So you have to be up to speed on kind of whatever's going on at the Human Rights Council or the Security Council and various things that are developing those kinds of softer law discussions, if you like.
So your distinction between the soft law and the hard law would be according to the source, or the effect because of the source, or
all of those things. The source, I mean, in international law, you've got if you go to, people will always point to Article 38 of the Statute of the International Court of Justice, which is the formal sources of international law, which talks about treaty law, custom, the general principles of law, and the writings of publicly recognised scholars. So that's in your kind of international law 101, you're told these are the sources of international law, so those are your hard sources one way or another, and even then it's really 99% of the time either the treaties and to a degree the customary law. The other two are very, in practice, subsidiary really. I would be shot by international scholars for saying that, but essentially that in practice that's true. And the difference between treaty and soft law, of course, is that states have ratified and bound themselves by doing so. They haven't done that in soft law. Soft law is statements of principle or aspirations or anything like that. So they can come through different kinds of ways. It can be through kind of preliminary discussions. For example, you might look at the International Law Commission's writings and various things, be it state responsibility and other things like that, where these things have not yet necessarily crystallised, but they may be taken also as indications of custom. But it's partly to do to where they're coming from. It's not states formally ratifying it, and it's also certainly the effects, because there would always be a debate about whether or not, and the real turning point for soft law is whether or not it's evidence of something becoming a customary norm. So the effect of it would be almost an incremental kind of crystallisation, if you like.
Yeah. Is it a continuum then, rather than hard, soft? Because I think some people would say that relative to some forms of law, even treaty-based international law might seem relatively soft compared with some other forms of law. So is it a polarity or is it a continuum?
I think, no, I would say there's a difference in the sense that simply from a state's point of view, if I were representing a state, I would be in fairly solid ground to say I don't have a clear obligation here. I would be in fairly solid ground most of the time to be able to say you can't prove to me that this is solidified, that this soft law is evidence of a customary norm. I mean, there's always a debate around those things. Maybe you're right, a continuum in that sense, especially with the formation. If you're using soft law as evidence of the formation of a customary norm, there is that kind of, simply by matter of time and practice, that you can argue that. But yeah, I mean, the point you're making, I think, you know, a lot of people would say international law, because it doesn't conform to the general expectations of enforcement in the way municipal law does, then of course people would, you know, that whole kind of coffee talk question, is international law really law, that kind of question. So you can see what I think of that question from that description of it. But yeah, so I think, yeah, I mean, it's clearly not international law and the kind of law that I've been working in, other than if you go into the International Criminal Court, which is obviously a much more black letter kind of institution. Broadly speaking, you're talking about that admixture of politics and international politics and law working its way out somehow or other, not through traditional court systems.
The issue of soft law almost always comes up in these interviews, and it usually comes up in response to the next question, which is how far is the body of shared legal knowledge amongst practitioners outside case law, outside legislation, and how important is it? It almost sounds to me as if you're suggesting there's soft law is part of that, but there are other things as well. That you can have a shared body of legal knowledge which is softer than soft law, if you want.
Softer than soft law. I mean, I think there's a distinction between, I mean, soft law generally would be substantive in nature, it would be speaking to principles or some, so not generally speaking procedural or about how things work. When I looked at that question in the past, I'd asked myself, is that a question different from a question about how things work? Is it the same as how things work? Because we, in a previous job, did a research project that was about how things work in transitional justice, as it was called, in terms of how states deal with the legacy of massive human rights abuses and things like that, and how do you set up truth commissions in practice, how do you set up national investigations bodies in practice, and all of that kind of thing. But I'm not entirely sure if the question is looking at the question of how things work and, you know, what are the secret codes behind the scenes of making things work better or getting the result you're trying to get through manipulating or navigating that system. In most of the work that I've done, most of the institutions are relatively immature compared to municipal law in the UK jurisdictions, for example, which I think also leads to the fact that kind of shared practices and ideas of the things that inform the operation of the law are less established and much more in flux than you would get in, you know, appearing at the Sheriff Court, appearing in the High Court, and, you know, all of the things that one knows about how to try and make sure things go as well as they can and you appear as to the greatest benefit of your client and all of those things. That's a much more fluid thing. I can give you one example of that. Back when I was working in Guatemala, this is the Civil War in Guatemala ended in December of 1996. And from just after that, for the next almost 5 years, I was working in Guatemala. Partly, a good bulk of that was presenting cases to the Inter-American Commission on Human Rights in relation to violations that had occurred during the war. And because the treaty had just been signed, or the peace deal had just been signed rather, between the insurgents and the government in '96, the Commission itself basically took the view to stop admitting petitions in relation to violations, because they took the view that a period of stability would be a good thing to allow. And what they said to us was, you know, to allow the state to show that it had, you know, basically taken advantage of the space afforded to it now to start implementing human rights and respecting human rights. Now, that was an absolute violation of their own procedural norms, in my view, and they got it kind of changed relatively quickly. But it was also an indication, in effect, the Commission had really only been dealing with cases for about 10 or 15 years. Only at that point, maybe 5 or 6 states had really been the engine of cases getting to them. And they weren't really all that sure of how to deal with certain things. And so the political antennae, if you like, were stronger than the juridical ones at that point. But there was no way, it wouldn't have mattered, what connections you had. There was nothing you could do about that. There was no kind of secret levers to pull behind the scenes or people to talk to. There was nothing you could do. And I think that probably changes over time. They have now got a more clear set of practices and a more clearly established rules of procedure. It's always the same, though, to some degree. I've heard some of the interviews talking about the simple fact of getting to know how things work and, how you would say certain things or present certain arguments in certain settings with certain judges, and you would go down another line with others, or you would prepare in certain ways for certain. The same is true in those kinds of things, but in the bigger things that are the more political things of trying to lobby for things to get onto a negotiation for Syria or stuff in Afghanistan just now and other things, those issues are not as relevant.
In terms of developing practices and procedures, is there some sort of fairly mutually familiar group of people who drives that, or is it constantly changing?
It's funny. Yeah, the world's a tiny place in all of these things, because it's depending on what particular area. I would say the answer to that is yes. So if you were to have a conference, I'm sure this is familiar ground for many of you here, but you go to conferences and you tend to see the same people fairly often, don't you? So the stuff that I would have done in the past on investigating genocide in Guatemala. So there's a group of people that have spent a fair bit of time investigating war crimes, crimes against humanity, and genocide. Especially people that have specialised in doing that in national scenarios as opposed to international courts. So that's a smaller group and different challenges and different kinds of appetites to some degree in terms of the less hospitable environment that you would do that in. So you tend to meet the same people working in those kinds of areas, and those people have had some influence in, at least, if not developing the law as such, in terms of developing the capacity for people at local levels to challenge things locally. So they have that kind of influence, and that's a relatively small group. If you go to things like the refugees and reconstruction issues, again, there's a set of people. If you look at, if you had a conference, I could give you about 10 names of people that will definitely be at that conference.
Yeah. What sort of size of group are these groups of people, and is there a core and a periphery, or?
Yeah, definitely. Because so many of these things are now driven by UN work in UN agencies, that also becomes a relatively self-selecting process over a period of time, and the UN tends not to be particularly good at looking beyond and refreshing that. I have to say that's a criticism I would make of them, that they tend to stick with their tried and tested group once they've got it, so that kind of feeds into what you're talking about. On the refugee thing, I would say you would probably be able, if you're talking about genuine discussion on the minimum conditions and the right of return, maybe about 20 people or something like that would be people that you would guarantee that would be in that,
right.
But a periphery could go into hundreds,
It's interesting, there does seem to be recurrent figures, one of which is 10 to 20 for something that people know need to be changed and they want to get somewhere, and then the community seems to be low hundreds. And those two figures have recurred from various people we've talked to.
I can't give you any radical change, I'm afraid. That's it.
Oh, it's just interestingly consistent. How far are there legal systems of interest to you? And you've got your particular area. Are you interested in other systems of law as well?
Yes, that's a short answer. Certainly what I've been doing for the last couple of decades, for a number of years I was working in Guatemala, which is a continental system in any event, so you had to get used to that in the whole, for criminal law. So in the jurisdictions you have in the UK, you have an adversarial system, continental systems have an inquisitorial system, even though most of those have been subject to fairly significant reform. But basically what that means is that the judges play a much more direct role in court proceedings and to some degree in investigative proceedings. So you had to get very used to that in that concrete situation. In a number of the countries I'm dealing with just now, the question about Sharia law is very significant. Work in Afghanistan just now is obviously a big issue there, Syria. becoming a bigger issue than it maybe was previously in Iraq as well. So other systems are directly relevant, for sure, be it on the division between common law and civil law traditions, but also in knowing, I mean, I don't pretend for 1 second to have become an expert in even Guatemalan law, where I was for 5 years, but you have to know enough to navigate and to know what questions you have to be asking. But yeah, for sure you have to, I've had to, I mean, it's interesting to me in any event, but you couldn't have done anything remotely useful without knowing something or being interested in the other systems.
And I think answering this question is fairly obvious from what you've already said, but how far are you interested in law in the abstract? And does that feed into your work, or is it just an interest?
No, it does. It's well, I've already confessed to you that I did a degree in philosophy many, many years ago. So all of the abstract stuff, you know, it's you said you wouldn't. You did say you would criticise it. I don't know, but the issue is, to me, the work that we do, or that I've been doing for a long time. For example, this organisation I work for, called the International Centre for Transitional Justice, that was established in 2001, and it was established in response to a growing development of what was called transitional justice, which was, as I've mentioned already, how states and the international community responded to the legacy of human rights abuses of repressive regimes. It was mainly about repressive regimes when it started, so Argentina, Chile, South Africa were the kind of trailblazers, if you like, in this question. But in essence, when one of the guy who founded the organisation said at one point, really this whole issue of transitional justice comes up when we have reached the limits of your legal and moral discourse. And effectively that all of the work that we're dealing with is at that point. So when you're dealing with mass atrocities, or you're dealing with the fundamental breakdown of the social contract, which is, you know, so in Syria just now, the negotiation, to the extent again that it exists, is about the creation of a constitutional committee under the supposition that amending the Syrian constitution will lead to something like an acceptable situation for people to go back to live in. But so people recognise that the constitution as it is doesn't work, or hasn't worked at all. But you're in that territory in almost all of the situations. I don't just mean it's about constitutional reform, it's something more fundamental than that. You're asking, consistently you're asking, not only what is the law for, but what are the necessary preconditions for that to be developed in a sustainable way. So you are really very much dealing at that level. And so it's certainly philosophical, it's certainly abstract in a way, but it's also very practical. You have to be thinking about how do we help to create the conditions that can re-establish any genuine discussion about the recreation of a social contract.
And do the practical demands affect your philosophical outlook?
Yes, in the sense that I was just talking to someone earlier on, say that the whole process is always one of regression, in the sense that you have in a sense an aspiration, of course, of what you want, but practicalities beat you down every time, so you're always reduced, whether it's in mediation or negotiation or any of these kinds of things, to accepting something a much paler reflection of the vision you might have imagined that at one point could have been created. And that can be both in terms of both qualitatively and quantitatively. You know, if you start off a process where you're looking for accountability for victims of mass atrocities in a situation where arguably hundreds of thousands of people have been killed or something like that, you'll end up maybe doing a case that deals with 500 or something like that. If you're lucky, that's the cases that we did in Guatemala ultimately. So it becomes a very diluted reality once you go through those things. But even in the bigger scene, you're always, especially when it goes through a mediation process, it's obviously going to be compromised, and things that are going to end up being in constitutional arrangements or institutional arrangements are going to be, you know, not what many people would draw up behind a veil of ignorance. You know.
Is this affecting your relationship between politics and political philosophy and moral philosophy and so on, or is it affecting your attitude towards the theory of law?
I don't know, I think it's age that affects my attitude to most of these things rather than philosophy. One gets older and I think slightly less idealistic than you were at some point. So I think I think if I'm very honest, I still think that the fundamental ideas that I would have had about theories of law and the underlying ambitions of law in society, which ultimately to me is about how do you enshrine in a practical way certain fundamental rights. Nothing much more glorious than that, not much more complicated. That's what most of the societies that you're working in are basically looking for at a very fundamental level. How do we make institutions accountable in the short to medium term? How do we guarantee certain fundamental basic rights? I know everything becomes very much more complicated very, very quickly, but in terms of the basic ideals of what it is you're trying to get to, and I don't think the experience has changed that. I don't think any kind of theory of law, the utility of law or the purposes of law, I don't think that has changed. If anything has changed, it's the context teach you that simple reality that you can't do the same thing in different places, that the reality in certain situations is very different from if you take a country that has got a fairly well-structured, fairly active, if you take the example of Argentina in the 1980s, the end of the junta regime after the Falklands War, you had a very educated, well-structured society, very well-educated victim society. Most of the victims of the juntas who were disappeared and the families of the disappeared, broadly speaking, came from, or at least a good number came from academic and activist societies. They were able to articulate grievance in a politically influential way. So the use of the law in that environment was a much more immediate and kind of valid way of communicating and was recognised as such. So it had a much more immediate impact in, if you like, reconstituting the rule of law. If you go to a country like Democratic Republic of Congo, where you could argue the state has never existed other than in name, Kinshasa has never ruled anything outside of Kinshasa, really. You're dealing with a country where the rule of law has never existed. So I think to go into a place like that and talk, to bring in the whole jargon of re-establishing the rule of law, you have to start somewhere else. You have to start actually a different level of what are the conditions for this to be a useful discussion. So that, I don't know if that's a different approach to theory or not, but I think that's a very hard thing to do as well, because it sounds like you're kind of giving up a little bit, and people would argue to some degree that you're kind of weakening arguments about universality and everything else, but I think there's a difference between universality and uniformity. The same values can apply, but how you get to those and the approaches that you take to making them real is not always the same, and you have to recognise the conditions that you're working in. So this context more than theory, I think, would drive differences.
We end up with two questions which may seem slightly tangential to the core of the questions, but actually do relate fairly closely. First of which is, are you interested at all in the history of law? And if so, or is there use of that in practical terms, or again, is it just something that is an interest?
Yes, I'm interested in it. And again, because you're working at really such a fundamental level of what law and constitutions and rights are all about, in most of the countries that you're dealing with, the discussion about what the law is actually a live conversation. It's a live issue. I mean, even if you go back, if you're in Latin America, very vibrant discussions, even in the late 90s, about Marxist ideas of an instrumentality of the law and all of that idea, and the whole class struggle around the law, very, very, very present in discussions. And so, a lot of people, a lot of the human rights organisations in Guatemala, for example, grew out of the insurgency itself. They became human rights organisations in one way or another, for example, and a lot of them would not want to engage in legal discussion. If you actually go into somewhere like Northern Ireland, for a long time, some of the communities from the nationalist side didn't want to engage in it. They've changed in the last 7 or 8 years. It's been interesting, but I used to do a little bit of work with some communities in Northern Ireland, and just round about the time of just after the Belfast Agreement, and discussions about accountability and things like that. And at that point, the discussion among the nationalist groups that I would talk to was that they didn't want to do anything in national systems. They wanted everything through the European system because they didn't want to recognise the validity of the British system. That's changed quite considerably over the last 20 years, but that goes directly to what the history of the legal system is and what they see the use of the system has been. So, yeah, I think in most of the places, because you're dealing with such kind of the nature of conflict in most of these places, the history of the legal system and the uses of the law is usually a relevant part of the discussion at some point. It doesn't always change things. The Northern Ireland example is an interesting indication of how things can change in a relatively short period of time now.
And finally, first part of this question is obvious answer, sorry, which is in what ways do matters of emotion enter into legally related work? And then is it a function of law to exclude emotion from disputes or to shape it? Or how do the two relate?
Yeah. Well, again, I think, yes, they do come in, yes, of course, especially in almost anything, be it a family law situation or a criminal law situation, a tax law situation. We all get pretty angry one way or the other. But in any of it, and the work that I've been doing, of course, if you start dealing with, 12 million displaced or massacres and genocide in Guatemala, then of course these are emotional issues, of course, without a shadow of a doubt. And is it the law's role to try and take emotion out of it? Yes, I think is the short answer to that. I can't see what the advantage of keeping it in would be to get to the beneficial solution. It depends what that means. So I still think you can be historically. So let's take, it shouldn't be the role of judges, for example, to come to a decision to lower the emotional charge in a society because it's an emotional case, or because there's 1,000 people demonstrating outside a courtroom. That shouldn't obviously drive the decision. The decision should be what the rational decision is on the basis of the evidence. So if it means taking emotion, it should take the emotion out of the case, not out of the cause, if I can put it that way, or whatever the bigger context is. That's I don't see the role of judges it's not to right the bigger social and political chaos that they might be dealing with. But yes, for the specific cases, and even in issues like trying to get issues about certain kinds of rights onto mediation discussions and negotiations, by the same token there, you are trying to take as much emotion out of it and get reasonable, practicable solutions into it and take as much of the emotion out of it. Emotion, broadly speaking, doesn't help negotiations, broadly speaking.
Fantastic. Let's start the formal part of the interview there, and there will be lots of questions, I hope.